As noted earlier, social and economic backwardness does not necessarily coincide with political backwardness. In this respect, the state government are well advised to reconfigure their reservation policies, wherein the beneficiaries under Article 243D subclass 6 and 243T subclass 6 need not necessarily be contemporaneous with the social and economical backward classes for the purpose of Article 15.4 or even the backward classes that are underrepresented in the government jobs. For the purpose of Article 16.4, it would be safe to say that not to all of the groups which have been given reservation benefit in the domain of education and employment need reservation in the sphere of local self-government also. This is because the barriers to political participation are not of the same character as barriers that limits access to education and employment.
Prabhakar, you're
The
not understanding why you're reading that. Try to understand. The state government, what it says is, it intends to amend 285 and it has submitted that bill before the governor. Governor has not given
He is reading
assent to
Krishnamurti.
that particular
He is
bill.
reading Krishnamurti.
Until unless he
Not
gives
the-
assent, it will not become law.
Because-
If it is not law, it can't be implemented. That's the only question. Please answer that. That's only, that goes to the root.
My,
Don't see all
my
those
lords,
things.
may I add, my lords, with lordship's permission, my lords?
Lordships,
Actually,
one sentence I can complete,
can
Lordships. Ramesh Okan.
oh, sure.
This calls for some fresh thinking and policy making with regard to reservation in local self-government. This is my humble submission, Miller. The government is having in this welfare legislation in the self-government having power to make the policy. This constitutional bench judgment at para 63 stated. That's my humble submission with great
So
respect.
beneficial legislation, it did not be sent to governor, huh? What is this kind of argument?
Lordships, the Honorable Supreme Court 5 judges bench, which has stated, I submitted before your Lordships.
They are saying that the proceedings are taken care of.
As long as 285 is staring at you, as long as 285 is not amended, you cannot come up with this.
And the Supreme Court. In fact,
If 285 is amended,
para
then
62
perhaps
favors the merits.
we can go into the merits of
Of
this.
Krishnamurti.
You must clear the first hurdle itself, state, must clear the first hurdle.
No, but his lordship.
That's the reason we are not setting aside that you are anything. What all we are saying is, let the government file extension petition before single judge seeking extension of time for conducting Panchayat Raj elections and wait for the 3 months in view of the latest judgment of Supreme Court. If no assent is granted by the governor, it becomes a law, then you can do whatever you want. That's the point. Suppose if we stay this, set aside this, then it comes back to the square one. Again, this one man petition. So much of exercise state government must have done. It all will go in waste. You must also support the petitioners. If you want this benefit, it should be in accordance with law. Because this exercise of GOMS number 9 is not in accordance with law. If you want to pour some life into 9, you must wait.
How can we support Millard for the past 75 years? We are not in the self-government in local bodies, at least 30 to 35% Lordships.
Right.
Mr. Prabhakar, we are not on merits. We are on
Legal issue.
legal issues. Legislative competence is an issue here.
My lords, may I submit, my lords? This is Ramesh Chilla.
Yes.
My lords, actually, the ordinance was sent to the governor, my lords, on 15th July, my lords.
అయినా 3
I-
months కాలేదు కదండి.
Yes, 15 more.
Yeah,
As your lord. Yeah, but that was delayed without no sending back, so that no the state government took the route in the legislative formulas and they introduced the bills in the assembly in the August 31st. Just I wanted to add that no, even
Yeah.
before.
If the state government give concurrence, you don't have any option to, you can take some time now because finalizing which candidate should contest from where and all those things. You are the
But I
person.
require 45 days, the day on which they give concurrence for conducting election.
So nothing will happen in this 1 week. You are not going to issue any notification.
We will be issuing a notification from that day, 45 days is
Huh?
From the date of consent.
from the date of the consent, when the concurrence is given.
No, when you will be issuing notification, election notification?
The moment they give the concurrence, because I have made all the arrangements.
With that form.
We have
Maybe,
only-
maybe in a day or two.
Yes. Because only the reservation issue and identifying the constituencies will be the role of the state government. All other paraphernalia we have undertaken. In fact, we addressed the recently also letter in terms of the directions of the learned single judge that we are willing to proceed subject to concurrence.
Suppose if we say, don't touch till governor gives consent, and we also helping them.
Learned AG has come. Yes. AG has come.
Yes, AG.
My lord, I am unable to get into contact with anybody. Your lordships may have it on Monday or Tuesday, my lord. Because tomorrow is Sunday, my lord. A little late in the evening, my lord, I am unable to contact it, my lord.
Then
Lordship
maintain
may-
status quo till Monday.
Yes.
They can't be, my lord, may I request one thing, my lord.
No, anyhow, Mr. Sudarshan Reddy, there are only 2 working days next week. All are general holidays.
Yes.
May I request one? I'm unable to, my lord, I'm not being made, my lord, allowed to make my submission. I'm appearing for the state, not for that petitioners who are there on a peevish issue of 42% and 38%. My lord, I'm not on that. My lord, elections cannot be conducted in 6 days, no matter election commission or the state. No elections can be conducted in 6 days, even if your lordships will have it on Monday also, or the 6th or Monday. Would an election be conducted in 6 days? My lord, notification, my lord, after a notification it is given, it's 45 days. 45 days time is given. My lord, you will have to identify each of the reservation points, whether it is reserved for lady, it is reserved for BC, it is reserved for SC. My lord, I'm surprised that a house motion is moved. 45 days is the notification time.
1 minute, we have understood. 1 minute. 1 minute. 1 minute. Election notification is not a challenge, but it already moratorium they have what it can be heard. Maybe senior, it's like this. Once election notification is filed, you cannot challenge. But these writ petitions are filed before notification.
yes.
So nothing will happen. So we'll have it on 6th, right?
My lord,
Yes, but-
Cases, once notification
Till
is
then
filed,
status-
1 minute, sir, what is my, not able to understand. Once notification is filed, you cannot challenge notifications and elections. Now, this writ petition is filed before notification, so we'll hear on 6th. As rightly Advocate General said, elections cannot be completed within 6 days. We'll hear this on the reopening day before a regular bench, right? Post on 6th.
Till
Obliged,
then,
deeply obliged.
Now that this is fallen from the honorable court, would it be made a part of the, because what happens is any steps taken by them. Otherwise, this rule of lease pendants.
1 minute, sir, 1 minute.
Your lordships have put up, just as my advocate general has made a very scathing comment on us that the peevish petitioners.
No.
But they may be peevish, but we
Millet,
also require.
If the
It's
if
a-
the notification
One
comes
second.
tomorrow,
We'll respond.
You
We'll
have
respond.
not understood.
What we are saying, your lordships are absolutely right.
Understood. 1 minute. Mayur, even if notification is there can't be challenge to that notification. These are all writ petitions filed before notification. They have to be heard and
Well,
dealt.
let it be observed by this honorable tribunal.
Huh?
Let this be an observation. Because
Yes.
what happens is the doctrine of dispendence may not apply in
Right.
case of an election notification.
Correct,
Your lordships may make it as a part of a court order
correct.
that nothing is going to happen.
Notice before admission. Post on reopening day, 6th or 8th. 8th October 2025. And it is made clear, even if the election notification is issued for conduct of local body elections, the cause in the present writ petition survives and it has to be heard on merits.
then status quo, madam.
What is? Pass such an order, right?
Obliged. That takes care, you don't get worried.